In 1938, Congress enacted the Fair Labor Standards Act to protect employees engaged in interstate commerce from substandard wages and excessive working hours. The act achieved its purpose by prescribing a maximum work week of 40 hours, unless an employee was paid at a rate of 1.5 times the regular rate of compensation for hours worked over 40 in the same week, and by prescribing a minimum wage for all employees engaged in interstate commerce. Although the Act ensures minimum wage and overtime pay protections for most employees covered by the Act, they do not apply to some white-collar workers, including those whose duties meet the definition of an executive, administrative, or professional employee and who are paid a salary that exceeds a minimum specified amount. The salary test has only been updated once since the 1970s, back in 2004. As a result, it has left millions without overtime protection. This outdated salary threshold provides overtime protections to only 7% of full-time salaried workers today based on their pay, compared with 62% in 1975. In fact, the white-collar exemption salary level set in 2004, which was $455 per week or $23,660 a year, means that workers earning less than the poverty line for a family of 4 may earn too much to automatically qualify for overtime. In May of 2016, the Department of Labor issued final regulations updating the salary level required for exemption to ensure that the Act's intended overtime protections are fully implemented. Specifically, the final regulations set the standard salary level at the 40th percentile of earnings of full-time salaried workers in the lowest wage census region, which is $913 per week or $47,476 annually for a full-year worker, and establish a procedure for automatically updating the salary test every 3 years. Additionally, the regulations amend the salary test to allow employers to use bonuses and incentive payments, including commissions, to satisfy up to 10% of the new standard salary level. The final regulations make no changes to the duties tests to qualify for the administrative, executive, and professional exemptions. Many church leaders are wondering how these new rules affect churches. Are ministers and lay church employees even covered by the Fair Labor Standards Act? And if they are, how can they minimize the financial impact of the new regulations? Well, it is essential for church leaders to understand that the Fair Labor Standards Act contains no exemption for religious employers. There are 2 ways in which an employee can be covered by the Act: enterprise coverage and individual coverage. Churches that do not engage in commercial activities generally will not constitute enterprises, but some church-operated schools and preschools may. But church employees that are not covered on an enterprise basis may still be entitled to the Act's overtime and minimum wage protections if they are individually engaged in interstate commerce or in the production of goods for commerce. The Department of Labor provides several examples of employees who are individually covered under the Act, including making or receiving interstate telephone calls, shipping materials to another state, transporting persons or property to another state, typing letters that will be sent out of state, handling records of interstate transactions, and travel to other states on their jobs. It is likely that regular use of the internet in sending and receiving emails and ordering products for the church would also constitute involvement in interstate commerce, triggering the overtime and minimum wage protections. Clearly, the test for individual coverage is ambiguous, but in general, church leaders should not assume that an employee is not covered by the Act without first confirming this conclusion with legal counsel, since a wrong conclusion can trigger liability for unpaid overtime and liquidated damages of the same amount, meaning double liability. The Department of Labor has acknowledged that infrequent and immaterial activities that implicate an employee in commerce are not sufficient, but it insists that in view of the remedial purposes of the Act, the application of this principle is limited to circumstances where the time consumed by an employee in doing covered work is obviously trivial, and the incidence of this covered work is so infrequent and out of pattern that it would be unrealistic to assert individual coverage solely on such grounds. Department of Labor regulations state that the Act makes no distinction as to the percentage, volume, or amount of activities of an employee that constitute engaging in commerce or in the production of goods for commerce. However, an employee whose in-commerce or production activities are isolated, sporadic, or occasional and involve only insubstantial amounts of goods will not be considered engaged in commerce or in the production of goods for commerce by virtue of that fact alone. And significantly, the regulations state that the law is settled that every employee whose activities in commerce or in the production of goods for commerce, even though small in amount, are regular and recurring, is considered engaged in commerce or in the production of goods for commerce. So again, church leaders should never assume that a particular employee is not subject to the Act's overtime and minimum wage protections on the basis of individual coverage without consulting with legal counsel. While many, if not most, lay church employees are covered by the Act's minimum wage and overtime protections because of individual coverage, ministers present a unique case. The official economic report accompanying the final 2004 Department of Labor overtime regulations strongly suggests that it is the position of the Department of Labor that ministers are exempt from the Act. For example, the report unequivocally states that clergy and religious workers are not covered by the FLSA. There are several other similar references. This probably is a result of the perceived constitutional issues that would be implicated with government intrusion into the compensation practices of churches with respect to ministers. This conclusion is bolstered by a unanimous ruling by the United States Supreme Court back in 2012, affirming the so-called ministerial exception, which bars the civil courts from resolving employment disputes between churches and ministers. And there have been a few other federal court rulings that have explicitly concluded that the government is barred by the First Amendment religion clauses from applying the Fair Labor Standards Act to ministers. One way for churches to understand and apply the new overtime rules is to divide all church staff into four categories: those who are clearly exempt, those who are clearly not exempt, those whose status is not clear, and ministers. Perhaps the most common and difficult status will be employees whose status is not clear. As I noted before, it is important for church leaders to be conservative in resolving the status of such workers because of the penalties the government can impose on employers that treat an employee as either exempt or not covered by the Act's minimum wage and overtime protections, and who the government later determines is in fact covered by the Act and not exempt from its protections. Let me illustrate the potential impact of the new regulations with a few examples. First, a church employs a manager of buildings and properties who meets the duties test for an administrative employee exemption. This employee often works overtime, and in the past, the church avoided any liability for overtime pay by paying him a salary of $25,000. Since this employee met the duties and salary tests, he was exempt under the Act, and so the church was not required to pay him overtime benefits no matter how many hours he worked in a week. This changes on December 1, 2016, when the new regulations take effect. Under the new rules, the salary test increases to $913 per week, or $47,476 per year. The church will need to pay this employee overtime for hours worked in excess of 40 per week, or it can raise his salary to $47,476 or more. Here's another example. Assume that a pastor works many hours of overtime and is paid an annual salary of $45,000. As of December 1st, 2016, will the church have to pay the pastor overtime pay because the salary test is not met? Probably not, due to the apparent position of the Department of Labor and some federal courts that applying the Act to ministers would raise constitutional concerns. Church leaders should consult with legal counsel to confirm that this position has not changed. There is one more point for church leaders to understand. There are at least three ways for churches to mitigate the new regulations' adverse impact on church budgets. First, a church can forbid or limit overtime hours. Second, it can reduce some employees to less than 40 hours of work per week. And third, it can increase the salary of employees who meet the duties test of an administrative, executive, or professional employee to at least $913 per week or $47,476 per year. I will be reporting on any additional developments as they occur.